All right, hello everyone, and thanks for tuning in to this webinar. Today we will be looking at the topic of advocating for immigrant victims of crime. We'll be looking at current options for stabilizing immigration status, sort of an immigration law survey, and also we'll be looking at best practices in working with immigrants. Before we get into the content, we'd like to introduce ourselves. My name is Diana Bieber-Locke, and I'm an attorney with the Community Justice Project, or CJP. Slide for you. Our mission at CJP is to protect the rights of low-income people in Pennsylvania. Our legal work includes, of course, free immigration legal representation to victims of crime, but also as a larger organization, we are statewide and we take on systemic issues in the areas of housing, public benefits, language access, better pay for workers, and other issues. Sarah, would you like to talk about yourself?
My name is Sarah Martin-Torres, and I am the state liaison for the Immigrant Survivors Project at the Pennsylvania Immigration Resource Center. And basically what we do at ISP is represent foreign-born victims of domestic violence, sexual assault, and human trafficking in immigration cases. And we also coordinate the Immigrant Survivors Advocate Network, which is a VOCA-funded alliance of domestic and sexual violence victim service agencies that are committed to making immigration legal services available throughout the state and to providing culturally and linguistically responsive victim services. So if you're listening in from a domestic violence or sexual assault agency and you're interested in learning more about joining the network, please do feel free to shoot me an email, and I'd be happy to discuss it with you. So now that that you all know who we are, let's move on to what we hope to accomplish during this 90-minute webinar. We hope that by the end of this webinar, you all will be able to recognize some of the immigration legal options that are appropriate for crime victims and their families, and that you'll understand how these cases fit into the larger immigration system. We also hope that you'll be familiar with the impact of some of the recent immigration policy changes and how that's affecting crime victims. And then finally, at the end, we're going to cover some of the best practices for serving immigrant crime victims and what your agency can do, some things your agency can implement to help keep immigrant crime victims safe. So the way we hope to accomplish those objectives is by first doing a brief introduction to some of the key concepts and terminology that you may hear around immigration and immigration relief for survivors. And then we're going to jump into the actual forms of relief. We'll cover the VAWA Self Petition, the I-751 Battered Spouse Waiver, the U visa, the T visa, and then we will cover some of those recent changes to immigration policy and the impact on survivors, and then we'll wrap up at the end with the best practices. So before we dive into those key concepts, we do have a short video that we hope you'll take a minute to view. It's helpful to get a sense of how immigrant crime victims are feeling and hear them explain their fears around immigration enforcement. We hope that this will really lay the groundwork for everything that we're about to discuss and help you better understand the perspective and experience of immigrant crime victims. So please do take a minute to pause the webinar and view the video. When you get to the section that they start talking, the governor of Texas starts talking, you can actually stop it there. Okay, so welcome back. We are going to review some of the key concepts and terms that you might hear throughout this presentation, really just to give you a really basic kind of framework and go over some of the terminology you might hear us use, although we will try to avoid using any, kind of jargon. You may hear folks refer to people who are in the United States undocumented as having entered without inspection. You may hear people say IWI. This is essentially referring to people who come to the United States often by crossing a land border, for example, and not presenting at a port of entry. You may also encounter folks who are here or who entered on a non-immigrant visa. These are folks who are authorized for a period of time in the United States that has kind of a definite end date, and they're supposed to return to their home country before their time expires. This could be someone on a fiancé visa, tourist visa, student visa. And this is kind of the other population of undocumented folks you may encounter who entered legally with a non-immigrant visa but then overstayed the time that they were permitted in the U.S. You may also see someone with an employment authorization document. Sometimes you hear people refer to it as an EAD or EAD, work permit. This is basically the document that authorizes folks to work legally in the United States. It doesn't actually confer any legal immigration status, although you might be able to find out what their immigration status is by looking at their EID. You also may encounter immigrant visas or somebody with a green card. These are folks who are legal permanent residents who are able to remain indefinitely in the United States and live and work here, as long as their status isn't terminated for any reason. And that's the photo that you see on the slide is what the current green card looks like today. And then finally, you'll also hear us talk about throughout the presentation U.S. citizens during this presentation, but some of the ways that somebody might obtain U.S. citizenship either through birth, derivation, or naturalization. So I know that's a really super brief overview, but with that, I will turn it over to Diana to cover some of the common immigration options for crime victims.
Great. Thanks, Sarah. So I'm going to first, Sarah mentioned 4 forms of immigration relief that we're going to talk about today. And the first 2 are the VAWA and the VAWA Self Petition and an I-751. And I think it's helpful to think of those as kind of a single grouping. Those forms of relief are usually most appropriate in mixed status families when there's abuse happening in the family. So it's helpful to think of those kind of as a unit, and then the U visa and the T visa, which I'll get to later, are kind of a unit also, and those are more cooperation with law enforcement and being a victim of crime, and not so much about family status. So we're going to start with protections for victims that are kind of grounded in our family-based immigration system. So let's start with a hypo that focuses on a mixed status family. We're going to talk about Juana. Juana meets her husband, Mark, while she is here in the U.S. on a tourist visa. So as Sarah explained, a tourist visa is a non-immigrant visa, so she had to show a visa, and was given a specific period of time to stay in the United States. During her visit, Mark and Juana spend nearly every day together, and at the end of her visit, he pleads with her to stay in the U.S. and marry him because he is afraid he will lose her if she goes back to Ecuador. To add to the pressure on her, she discovers that she's pregnant shortly before she's due to go back with Mark's child. And in the end, she does agree to stay. And they get married right before that period of stay, usually 6 months, that she had authorized before that expires. Months go by, they have their first child, but no further action is taken to stabilize Juana's immigration status. So Sarah, I have a question for you. If Juana were your client, or she came to PERC looking for help, what would you tell her about her status, and what would she need to do next?
Well, it sounds to me, based on the facts of the hypo, that Juana is currently undocumented. We talked about those 2 ways to be undocumented in the United States, either entering without inspection or overstaying the visa, and it sounds like Juana has overstayed her visa. And although she is married to a U.S. citizen and she now has this U.S. citizen child, it sounds like they haven't taken any action, and what would ideally happen is that Mark would file for Juana so that she could obtain a more permanent legal immigration status.
Mm-hmm. And at this point, if she were to encounter like an ICE agent or something like that, could she be put in removal proceedings?
Yes, absolutely. She's got no pending application and she has no legal immigration status.
Okay. So if all goes well, Mark is going to submit an application for her after meeting with you, and she could have a green card then in maybe a year or so. But what if it doesn't go well? So let's turn and talk about part 2 of this story. And as I'm describing this, I encourage you to jot down any aspects of the story that seem relevant to you, because we're going to look at this hypo as I go through the VAWA Self Petition. So in our story, Mark tells Juanita that there is no need for her to have legal status because she's staying home with their baby. He gets increasingly irritable and controlling. He frequently monitors her cell phone and social media activity. He doesn't like her to leave the house by herself. She has to plead with him to allow her to go shopping for diapers or to buy food. When he's upset, he is constantly threatening to divorce her and get her deported. And he always mentions that he would keep the baby in that case. He also abuses her sexually, forces her to have sex even when she says no. Juana becomes depressed, she loses a lot of weight, and she has trouble sleeping. She wants to leave Mark, but she is terrified that she will be deported and never see her son again. She still hopes that he might file for her someday. What can Juana do? So prior to 1994, there wasn't very much that Juana could do other than stay in a dangerous and abusive relationship and hope that he does eventually file for her, or leave him and potentially face deportation, which is just a horrible choice. This changed in 1994. With this law, passing VAWA in 1994, Congress took what I like to think of it as the first step to recognize that although we do have a family-based immigration system in the United States, which allows U.S. citizens and legal permanent residents like Mark to petition for their family members to also have legal status, this system was set up to benefit families. However, it can also be used as a tool of abuse and control because it gives so much power to the person who has the legal status to take this first step to apply for the other person. With the passage of VAWA, though, this allows the family member who doesn't have lawful status, who is WANA in our hypo, to self-petition instead of having Mark petition for her. This need for protection of being able to self-petition comes up probably most frequently in abusive marriage relationships, but it's not limited to a marriage relationship. It also could include child abuse, when the abuser is a U.S. citizen or an LPR parent, because both U.S. citizen parents and legal permanent resident parents can apply for their children to get lawful status. And the VAWA Self Petition could also be an option in situations of elder abuse, if the abuser is an adult U.S. citizen son or daughter. Because again, U.S. citizen sons or daughters, once they turn 21, are able to petition for their parents. In all of these cases, whether it's spousal abuse, child abuse, elder abuse, the victim is able to self-petition for lawful status in the U.S. without the involvement of the abuser. The abuser most likely, hopefully, will not even know that they are pursuing this relief on their own. So let's look a little more closely about why this can be so helpful and what WANA would have to do to ensure that she qualifies. So first of all, what are the protections of VAWA? So first, even before the petition is mailed, even before it's approved, there are protections. The first thing that the applicant would receive would be a receipt notice, and then at that point she does have an application pending, and if she were to have an encounter with an ICE agent, she would be able to show that, which could offer some protection to her. And then the next thing that would arrive in the mail after USCIS has done kind of a cursory review of the application to be sure that it's potentially approvable, they will issue what's called a prima facie determination. This notice allows, with this in hand, WANA can go, at least in Pennsylvania, she can apply for a state ID or a driver's license, and this notice will also make her eligible for some public benefits. Depending on the situation, the VAWA self-petitioner may also be eligible for a work permit while the application is pending. This depends whether each case may be a little different. If the abuser is a U.S. citizen, then the victim is able to get immediately in line to apply for a green card, and because there's a green card application pending, they're eligible for a work permit at that time. That would apply to WANA. In some other cases, if the abuser is a legal permanent resident, in most situations, the victim is not able to apply for a green card immediately. They would be only submitting the VAWA self-petition, so they would have to wait for a work permit until the VAWA self-petition is approved. So let's turn next to what the elements are, what you need to show as part of the VAWA self petition. First, you need to show that you have a lawful relationship to the abuser and that the abuser is a United States citizen or a legal permanent resident. Part of showing that lawful relationship in the case of a marriage relationship is showing that the person was married in good faith, and we'll talk a little bit more about that in later slides. Second, you need to show that you as the victim were battered or subjected to extreme cruelty by the abuser. Sometimes this can be shown not only by showing direct abuse to the victim, sometimes that may be hard to show or may not really be sufficient. It's also possible to show abuse to children in common with the abuser. So in the instance the hypo that we discussed, if there wasn't much to show abuse directly to WANA, but we can establish that Mark is abusing their child that they have in common, that could also form the basis of a VAWA self-petition. Third, the self-petitioner has to submit evidence that she resided together with the abuser. And finally, the self-petitioner has to show that she has been a person of good moral character for at least the past 3 years. So let's look at each of these elements. For the first one, you need to show that you have a valid relationship to the USC or the LPR, and that has to be one of the qualifying relationships that I mentioned earlier. So this has several parts. If it's an elder abuse or a parental, a child abuse situation, the relationship can usually be established fairly easily with just a birth certificate. In the case of marriage, it can also often be established easily as well with the marriage certificate. Generally, the marriage has to be valid and current. So how do we know if it's valid? A key in determining whether it's a valid marriage is to ask the question, was it valid and lawful in the place where it occurred? It's important to keep in mind that to be valid for U.S. immigration, the marriage does not have to have occurred in the United States. Sometimes clients get confused about that and they think they're not really married because the marriage happened outside the United States. That isn't the case. It's recognized under immigration law so long as it would have been recognized in the government of the place where the marriage occurred. Sometimes this might require a little research, even state to state. Those laws about what makes a valid marriage may differ, primarily in the case of common law marriage, which is recognized in some states but not others. In general, the marriage also has to be current. There is an exception in the case of divorce. If you're working with an individual who was in an abusive marriage but was recently divorced, as long as the divorce became final within the last 2 years, they're still eligible to submit a VAWA Self Petition. Another kind of variation on this requirement of showing a valid qualifying relationship to a U.S. citizen or legal permanent resident could occur in the case of a marriage to an abusive legal permanent resident. If the victim had been married to a legal permanent resident who was abusing her, and as a result of that abuse, he wound up deported, and she's still married to him or within 2 years of divorce, although he, due to his deportation, is no longer legal permanent resident, she can still file for VAWA within 2 years of the deportation. And I should also mention that although I'm using male-female pronouns in describing VAWA self-petition process, it is open to men as well, and there's no requirement that it be abused by a man on a woman, or it could even be a same-sex relationship. But just for convenience, I'll often be using those pronouns. And second, as part of this, not only showing the valid relationship, it's also important to also remember that you need to establish that the abuser is, in fact, a United States citizen or legal permanent resident. Generally, this is not too hard to do. You could submit a copy of that person's birth certificate, their passport, their green card. But often, when there's abuse, this may not be that easy to do. Let's say, for example, in this situation, what if Juana came to you, Sarah, and she knows Mark is a U.S. citizen, that's what he's always said, but she's never actually seen his passport or birth certificate. What would you suggest for her?
That can be a really tricky situation, but generally, you want to try to collect any type of evidence that you might have available to you that does establish that they are a U.S. citizen. Some things that we might include, for example, on the marriage license, it often will list the place of birth, or if there's any kind of documentation, forms, applications that list the abuser's place of birth, if they're a U.S.-born citizen, or they're born, for example, in Puerto Rico, that may be helpful in establishing it. If the person is if the abuser is a naturalized U.S. citizen, or they're a legal permanent resident, you can also ask immigration. You can provide USCIS with all of the information that you have. Maybe you know their social security number, or if they're an LPR, you might know their alien number. Although you don't have a copy of that actual green card, you can ask immigration to verify that information, because obviously they'll have a record of it.
Mm-hmm. Yeah, right. So anyone, even someone who may have previously petitioned for a different spouse, it may be fair to assume that immigration may already have on file a copy of their immigration status, and you can ask them to do that too. And in part, some of these alternate forms of documentation work because all of these forms of relief that we're going to be looking at today are adjudicated under an any credible evidence standard. And what that means is, although USCIS would prefer to see the best evidence, they prefer to see a passport, due to the fact that so many crime victims are leaving a very dangerous, unstable situation, it may not be possible for them to get that best evidence. And so USCIS will also consider any credible evidence. And the rule generally is that they'll afford it the weight that they feel is appropriate given the nature of the evidence. So, for instance, in the case of an affidavit, they probably would put more weight on an affidavit that is notarized or on letterhead as compared to a handwritten letter on a piece of a notebook paper. But nevertheless, you could submit both of those, and they would be considered. So in addition to showing that the marriage is valid, and this requirement on this slide would only apply to VAWA Self Petitions that are based on spousal abuse, obviously. So in addition to showing that it's valid and lawful in the place where it occurred, it's also necessary that you show that the marriage occurred in good faith. When the focus in this inquiry is to look at the intentions of the self-petitioner at the moment she decided to get married. It could be an arranged marriage, so maybe the person didn't really know their spouse before they got married. Not always marrying for love or things that we might think in Western culture are generally a prerequisite to marriage. What you're really trying to show is that you didn't get married only for immigration purposes, and that at the moment you got married, you did have an intention of establishing a life together with this person. So going back to Mark and Juanita in our hypo, what types of things might she submit? And this wasn't an arranged marriage, so they may have letters that they exchanged or Facebook messages. They might have photos of them together. They might have letters from people who, they might be able to include letters from people who know them and socialize with them. One of the best pieces of evidence they probably have, though, is they have a child together. So that's also a very powerful piece of evidence, especially, they're both listed on the birth certificate. Maybe they sent out birth announcements together. Ideally, what USCIS would probably prefer to see, or especially want to see, are evidence of joint financial commingling. But again, it seems like from the situation that Juana is in at this point, it sounds like Mark is very controlling, and so he may not have added her to a bank account. They might not have joint credit cards and things like that, but certainly if those exist, those are things you would want to include as well. And probably the most important piece of evidence in establishing good faith marriage will be Juana's own declaration, because she can talk about the reasons she chose to get married. And in her case, I think showing the timing of when she found out that she was pregnant would also probably be helpful, because she otherwise can say, I was really planning to go back to Ecuador, but then I got married and I wanted my child to have a father. So I think that could be very persuasive. All right, moving on, the third element, I guess the second element in the list that I had given, is abuse. The language of the statute says that the applicant has to establish that they've been battered or subjected to extreme cruelty by the U.S. citizen or legal permanent resident family member. Really what that's looking at is both physical, it could include either physical and or mental abuse. Depending on the situation, this may be not too challenging to document, or it could be very difficult to document. The types of evidence we might hope to be able to submit would be things that you probably also are thinking of as you're listening to this: a police report, photos of bruising or other injuries, hospital records if there were physical injuries, a PSA, a conviction for a DV-related crime. All of those things would be great if it were to exist. Unfortunately, the victim in our hypo, Juana, doesn't have any of this. So what are some things that she might be able to include instead? And some things that occur to me is she has family members who may be aware she lost weight and she was having a lot of trouble sleeping. Sometimes I've had clients include before-after pictures that show how much weight they lost due to the stress. If she's seen a doctor for any trouble sleeping or anxiety, those types of things might be helpful. I would always, it doesn't sound from this hypo like Juana has gone to a domestic violence agency for victim services yet, and I would certainly make that referral right away. Then a letter from the DV agency can be really helpful as well in establishing abuse. There may be neighbors who are aware of what's going on, if they've heard anything. And then finally, again, her own declaration. And it's really important to work very closely. We work really closely with our clients. If you're not familiar with the power and control wheel, particularly if, in a spousal abuse case, but really in any family-based abuse case, that's really important to look at, because it talks about the many different ways that abuse can happen. She experienced isolation, financial control, abuse through threats about her child, abuse related to threats to deport her. Anything else that occurs to you? Sarah, I think that's, if you could make a referral to a psychologist to do an evaluation, that could also be really, really powerful. So, and again, I would say, especially in a case like Juana's, where primarily we are looking at mental abuse, like there was some sexual abuse too, that would be really important to mention. A lot of what the adjudicators are looking at is kind of a before-after. So being able to show, possibly in letters from family or people who've known her for a while, that this is what Juana was like before she married mark, and this is how she's changed. She's become a very fearful person. I don't have contact with her anymore. She's very stressed, and, before that, that's not at all how she was, and that can really help to show the existence of extreme cruelty or mental abuse. The third element is to establish joint residency. If you've already submitted evidence of good faith marriage, often some of that same documentation can help to show that they did truly live together. If there's, for instance, mail that they received together, pictures of them together in their home, maybe there's a lease agreement that has both their names on it, that would be ideal. Again, this is something she'll mention in her declaration that they live together, but other people who visited in their home may also be willing to say, yes, I visited them in their home. I'm very well aware that they live together. Finally, the VAWA Self Petitioner has to establish that they are a person of good moral character. What is moral character? One USCIS interpretation says that good character is measured by the standard of the community, but does not necessarily require the highest degree of moral excellence. So this does not tell us a lot. There's another place that we look in the definitions section in the INA, which is the Immigration and Nationality Act, but interestingly, it is defined somewhat in the negative. The definition of good moral character is more of a list of things that can prevent you from showing that you have good moral character. For instance, if you're a habitual drunkard, that's the language in the statute. If you've committed certain crimes, if you have made a false claim to U.S. citizenship, if you've given false testimony for the purpose of obtaining a benefit under the Immigration and Nationality Act. So if you have committed any of those things within the past 3 years, in most cases you may be barred from showing good moral character. And if I were to learn that about Juana, that she's barred from showing good moral character from something that she did during the past 3 years, I would have to tell her we're going to have to wait. And then ultimately, in the end, it's a discretionary decision. And because it is discretionary, that can, of course, against the client, but it can also work in their favor because it allows me to counsel my clients that they, any bad acts that they have in their past, maybe like a shoplifting conviction or something like that, could be balanced out during these 3 years by very good acts. So she can get involved in the local community, do some volunteering, things like that. That can be really helpful in balancing out anything that you're worried might make a good moral character finding hard to obtain. So in the end, assuming Juana can show all these things, we can submit the VAWA Self Petition for her. And in her case, because she's married to a U.S. citizen, we would also be submitting the application for a green card and a work permit. She will have access to public benefits, the ability to work, and hopefully be in a much more stable situation, which will open up more options for her as she makes decisions about her marriage and her life. That's the VAWA Self Petition, and now I'm just going to shift the story slightly to cover the next form of relief, and we're going to stay with Juana. And this second form of relief is the 751 waiver. And again, this is very tied up with the family-based immigration system, and it's all about mixed status families where abuse is happening in the family. So to tweak the story slightly, what if instead Mark did apply for Juana after her authorized stay as a tourist expired, and she had a work permit, and then she got a green card? However, because they've been married less than 2 years, fewer than 2 years at the time she received this green card, someone in that situation is not going to be issued quote-unquote normal 10-year green card. Instead, what she would receive would be a 2-year green card, which is called a conditional green card. And the way that you can check this, if you're working with someone who thinks they might be in this situation, is look at the green card itself. There's a 2 dates on it, the date that shows when the legal permanent residency began and the date that it will expire. And if it's only 2 years, it is a conditional green card. In order to obtain the 10-year green card, in a situation without abuse, is the person with the conditional green card applies together with his or her spouse to show at the 2-year point, to show that they are still together, that maybe they have kids together now, financial commingling, the same types of evidence that we would have submitted, we just discussed in order to show good faith marriage. You basically are showing it's still a good faith marriage. The rationale for this from a policy perspective is just yet one more check to make sure that there was no marriage fraud when the original green card was granted, because there's such a fear of marriage fraud. So let's change the facts now in Juana's hypo just a little bit. So let's say that even though she did receive a green card and now does have a stable green card, it is only good for 2 years. And during this 2 years, Mark's abuse against her seems to escalate because her green card is only conditional. Mark tells her he can have her deported if she calls the police or tells anyone what's going on. Juana knows that she needs him at that 2-year mark to file for her permanent green card. And Juana's friends tell her, just stick with it. Get your 10-year green card and then leave. You just have to wait. You're almost there. She doesn't know if she can take it. The good news when you're working with someone who is in Juana's situation is to tell her that she does have options. She does not have to stay in that situation. There's similar to the VAWA Self Petition, which allows a victim to apply on their own. There is a version of that at the 751 stage to have the conditions lifted, called an I-751 waiver of joint filing. There's a number of different reasons someone might want to file on their own. They're listed here. One might be if the spouse has passed away. Another reason could be maybe the marriage was entered in good faith and you would need to show that, but since during these 2 years the marriage has been terminated by a final divorce or annulment. That can be an option to do that would allow you to file on your own. The third option would be if, as we see in the hypo I gave with Juana, if there has been battery or extreme cruelty during the marriage. In order to file under this option, Juana would have to show that the marriage was entered into in good faith, and we already talked about how you do that, but that during the marriage she was subjected to abuse or subjected to extreme mental cruelty. And again, that would be the very same types of evidence that we just discussed. And finally, it's possible to file on your own without your spouse in the case if you can show that there would be extreme hardship to you if you were to be deported. So we do a lot of these here in our office. If multiple of these categories apply, you could, it's the same form, so you can just check each of the categories that would apply. And one advantage to, if there has been battery or extreme cruelty, to having your 751 waiver approved on those grounds is that the person retains the ability to apply for citizenship after 3 years with their green card instead of having to wait 5 years, which is what would apply in the other cases. So that's just, sometimes people ask me, should I do divorce or should I do battery or extreme cruelty? That's really the only advantage. The key is that someone does have a way to move forward with their life and to obtain that 10-year green card without having to file together with an abusive spouse. All right, so that is the end.
Can
There's
I
something to
add?
add? Please,
On the 751, I think it's important to note that in the normal process, they generally can't apply until I think 90 days before the conditional residency expires. But if you're doing the waiver based on battery and or extreme cruelty, you can file it at any time. So she may have only, for example, if Juana, just received her green card 4 months ago, but there's abuse happening, she can apply right then, and she doesn't have to wait until 90 days before the conditional residency expires. And I also wanted to mention that with both the Battered Spouse Waiver and VAWA Self Petition, there is no requirement, while it's helpful in the 751 context to let someone know so that they don't feel like they need to stay in an abusive relationship, there is no requirement that they separate from their abusive spouse. So we have both worked with folks who choose to remain in the relationship, and although it can be a bit more tricky to work with them, there's no requirement that they leave their spouse. I just wanted to point that out.
Yeah, and that's a great point. And there's also, and we didn't see this with Juana's case, but it's important to note, just as a general matter, there's no requirement that they report what's happening to them to the police. They could, only tell me, and I could do it just based on that. I would always encourage them to seek services, victim services, because that is better for them and would also help document the abuse. Another sort of general matter to note is that for the most part, these applications are often approved without or adjudicated without an interview. So part of the reason we're focusing so much on all the types of evidence you would submit is that may be all that USCIS, all the data that they're gathering and making their decision. They're not actually going to have an interview with the person. The exception to that is occasionally for 751 waivers, we will get interview notices, but not in all cases. And then after the self-petition is approved, as someone moves on to apply for a green card, assuming they're eligible to do that, there will always be an interview at the green card stage. But at the VAWA self-petition stage, there's no interview. And a final note is that There's no fee to file a VAWA Self Petition. That's a free form for immigration. There is a fee for the other applications that I've just mentioned, but if someone is very low income, they may be eligible for a fee waiver. All right, so that's all I have on this, and we're going to move now to the next form of immigration relief. We're going to really shift and look at U visas and T visas now, and we're going to have a hypo. Okay, Sarah will read to us.
So although a lot of these protections began in the family violence world, the same dynamics that can keep victims of family violence silent and afraid to seek help can also impact victims of other crimes and make them fearful and reluctant to cooperate with law enforcement. So with that in mind, let's take a look at Anna. Anna and her mom came to the U.S. from the Dominican Republic when she was 5 years old. She's been living and going to school here ever since and doesn't even realize that she's undocumented until she's in middle school. When she's 14, a neighbor sexually assaults her. He tells her that if she tells anyone, she and her mother will be deported. She struggles to cope with the trauma and eventually confides in a school counselor. The neighbor, who is a legal permanent resident, denies everything. His family in the DR tells her family she better stop making stuff up or he'll tell everyone she's undocumented and get her and her family deported. Despite his threats, Anna and her mother report the abuse to the police and cooperate in the investigation. So what do you think, Diana? Does it sound like VAWA would be an option for Anna?
So we do have child abuse, which I listed as a form of victimization that may work for VAWA, but what we don't have here is a family relationship. The perpetrator in this case is not a family member of Anna's, and can be helpful to remember conceptually that VAWA only works if the abuser could have applied for the victim, and in this case that doesn't exist. So unfortunately, even though Anna has lots of reasons to be really worried due to her immigration status, VAWA is not an option for her. So there's good news, though. Even though VAWA would not be an option for her, there's another form of relief that would work, and this was passed a few years after VAWA, and that is the U visa. This was brand new visa, non-immigrant visa category, just like a tourist visa is a non-immigrant visa, a fiancé visa. You know, we talked about non-immigrant visas earlier. This does fall into the category of non-immigrant visas, and it has a twofold purpose, the reason that Congress gave when they created this. It does have a very explicit law enforcement purpose. It is intended to strengthen the ability of law enforcement agencies to basically to do their job and to have victims who are willing to work with them. And then the second explicitly stated purpose is to offer some humanitarian protections to victims of crime. How does it offer those protections? Let's look at the benefits. If the U visa application is approved, the applicant will receive 4 years in U non-immigrant status, and during those 4 years they'll have an automatic work permit so they can work. They will have the option after 3 years with U non-immigrant status to apply for lawful permanent residency. It's not a guarantee that they'll receive it, but they have the option to apply. And then in addition, which is really an amazing benefit, many of their family members, depending on their relationship, living in the U.S. and abroad, may be eligible to also receive a U non-immigrant status with the option to apply for legal permanent residency. The rationale behind that is that, as we saw in Anna's example, she's worried not just for herself, but she's worried for her family, I believe, for her mom. Yeah, so both Anna and her mom, who are both undocumented, can receive some protection if she were to apply for a U visa. Those are the good aspects of the U visa. Those are really positive. The kind of unfortunate aspect to this is that when Congress created the U visa, they put a cap on the number of U visas that could be approved per year. By statute, Congress has said that USCIS can only approve 10,000 U visas per year. Currently, many, many more than 10,000 applications for U visas are submitted each year, which has led to a long wait list. And on top of that, in part due to the high volume of applications that USCIS is receiving, there's very long processing times. I think the last right around now, I believe USCIS is processing applications that were received maybe 2015, I think. So that just gives an idea of how long someone's going to have to wait to even be placed on the wait list. Once they're on the wait list, they will receive the option to have a work permit. And then once their number comes up on the wait list, they would then launch into those 4 years of U non-immigrant status. But that is hard. That's a really long time for a vulnerable person who's just experienced, been a victim of crime to have to wait to get that stability, which was really the whole idea in the U visa in the first place.
And if you just maybe explain what you mean by get on the wait list. How does one get on the wait list?
Sure. So what happens after you apply for a U visa, your application is waiting for someone to look at it, and right now, as we said, they're looking at the applications that were filed in 2015. So let's say 4 years pass, and finally you have an adjudicator looking at your case. That adjudicator, your application, the adjudicator will review everything, and if the adjudicator determines that were a U visa to be available, had they not already given out all 10,000 visas that year, he or she would approve the case. Instead, will issue you, a letter that says basically just what I said. Your U visa application looks good. It looks like it's approvable, but we can't approve it now because there's no visa available for you. Instead, I'm giving you what's called deferred action status, which will allow you to apply for a work permit. And then once you're on that wait list, it's not a transparent thing. There's no website you can go to and see where you're at on the wait list at this point. Maybe someday we'll have that. The only thing you can do is just check and see, check with other advocates, check with other attorneys to kind of see where we're at with approval. Despite the long wait, it's still a very important form of relief. And for many of my clients, and I think Sarah's clients too, it's the only option. They can't do anything else, and it is a great way to stabilize their status and provide a little long-term security. As set out in the statute, 4 main things to keep in mind. The applicant has been a victim of certain enumerated criminal activity, and what that means is there's a list of crimes that allow someone to apply for a U visa if they've been a victim of one of those crimes, that the victim possesses information about that criminal activity so they are able to be helpful to law enforcement, and that in fact they have been helpful to law enforcement. Either they have in the past, they're currently being helpful, or they're likely to be helpful in the future in the investigation or prosecution of the criminal activity. They also need to show that the criminal activity resulted in substantial physical or mental abuse. So basically we're talking about the impact of the crime on the applicant. You need to show that that was substantial. And then finally that the criminal activity violated the laws of the United States. The final point, which is just a side note, is that in order to be, the side note but that kind of can take over the whole process, in order to be granted any visa, any entry to the United States, a person needs to show that they're admissible to the United States. And that's something that we'll talk about a little bit later when I get to that slide, but just as a note now, there's many different things that someone can have in their past or actions that they've taken in the past that would make them inadmissible to the United States. And one of the reasons the U visa is so popular is that many of those grounds of inadmissibility, which would constitute a bar in many cases, can be waived for the U visa, and someone can be granted a U visa anyway. Looking at these elements in turn, for the U visa, who is a victim? In order to apply for a U visa, you need to show that you were either a direct victim or an indirect victim of the criminal activity. In the case of Anna, who would be the direct victim? Sarah?
I think Anna.
I think you're right, yes. Could there be any indirect victims in this case? Let's say, what if Anna were actually a U.S. citizen? Is there an indirect victim that could be looking at a U visa here?
Yes, depending on the age of the direct victim, the parent may qualify as an indirect victim, or, as you said, if the victim is a child and they're a U.S. citizen, maybe the parent could qualify.
Right, and I don't want to spend too long with that because we don't see it that often. Most often this will come up in my work when I have a child victim who is a U.S. citizen and that child's parents may be undocumented. And I think particularly as advocates working with victims of crime, it's really important to keep this in mind, that even though your victim, the main person you're focusing on, may be a U.S. citizen, or as far as you know may be a U.S. citizen, they may have other people in their lives that they're very, very worried about who are not U.S. citizens and could potentially benefit from the U visa. This could also happen in the case of an adult direct victim if that direct victim has been deceased. The crime is actually murder or manslaughter, so the direct victim is deceased or incompetent, incapacitated in other ways. But usually it comes up in the case of children. We're looking at victims of these specific crimes. It's a long list. Domestic violence is one of the most common crimes that people are basing U visa applications on. Other important ones that I've worked with, sexual assault. For the most part, these are not the category, whether it's a misdemeanor or felony doesn't matter, but I would note that in the case of assault, it does need to be felonious assault. Another important thing to note about this list is these are not actual crimes that would correspond to something in a state criminal code. These are categories of crimes. For instance, domestic violence is not a crime in Pennsylvania. That's not the name of how someone would, that's not what someone would be charged with. So this could look a little different depending on the state. You might see someone charged with terroristic threats or harassment, but yet you could still apply for a U visa because what was going on was domestic violence. So that's important to keep in mind when you're determining whether this could be an option for a client. How do we show that someone has been helpful in applying for a U visa? There's multiple ways. Of course, there's lots of ways to document that. You could show that they received subpoenas. You could show in their own declaration that they cooperated. But there is one form of evidence that you have to include, and that is Form I-918 Supplement B, which is confirmation by the law enforcement agency that the person cooperated. I mentioned when we were reviewing the VAWA Self Petition that USCIS is very understanding, and they go with the incredible evidence standard, and if you don't have the main form of evidence, they'll accept something else. That is not true for the U visa law enforcement certification. If you're unable to obtain a certification from the VA or the police or other law enforcement agency, you're unwilling to sign confirming that your client was a victim, you're not able to move forward. You're not able to file. So it's important to make friends with your potential certifiers, to develop a relationship there. When you're talking with, if you, for instance, are working with someone who's been a victim of crime and you want to approach the local police chief to ask that she sign your law enforcement certification, and this is an agency that's not familiar yet with the U visas, things that I would be sure to mention is that it doesn't require that the cooperation doesn't require, it's not required that it have led to a conviction. In many of the cases that I've filed, the only cooperation that we may have at that point is just the report. Could be that after the victim reported what happened to them, the perpetrator fled. It could be that maybe they wound up being deported on something else and they were never able to conclude the case. And there could be a variety of different reasons. But it's very clear that a report only may be enough for someone to sign a law enforcement certification. The key is that if the case did not move forward, it wasn't due to the victim's decision not to show up and not to cooperate, or the victim's decision to retract what they had said occurred. It's also important to note that there's no statute of limitations on helpfulness. The very first U visa case that I ever filed was based on a crime that occurred before the U visa was even a thing. It was, prior to the passage of the law that created the U visa. It's unusual. That would have been a crime that occurred almost 20 years ago, and it's very unusual to be able to successfully file a U visa based on such an old crime, in part because it may be difficult to get the certification, and it might be difficult to get some of the evidence that you would need, but it could be possible. And then also the cooperation doesn't require anything specific. You wouldn't have to necessarily testify or do something at trial or do anything specific. It's just based on, the key is that you've not blocked the process from moving forward by failing to cooperate. I covered some of this already, but when you're working with a certifier, in addition to things I mentioned, you would also want to note, I always tell the certifiers, you're not actually granting this person a U visa, although it's required that I can't do this without you. USCIS is going to be considering many other forms of evidence, there's many other elements, not just your certification. All that you're certifying with this, all that you're verifying with your certification are primarily two things: that the individual was a victim and that the victim was, is, or is likely to be helpful in the investigation or prosecution of the crime. Technically, the certification can be revoked if the victim stops cooperating. However, the law enforcement agency has no affirmative obligation to kind of keep track on what's happening in all the cases that they've signed certifications for. I would always recommend, too, if you're having difficulty working with certifiers, that you consult with the DHS UNT Visa Law Enforcement Certification Guide, which is available online, and it addresses many of the points that I just mentioned in terms of the fact that a report may be sufficient, the fact that law enforcement can certify on behalf of an indirect victim, like a parent of a child sexual assault victim, and it can be very helpful, and it's nice to be able to offer that information directly coming from the Department of Homeland Security, and it's not just the attorney making those arguments. Okay, the third element is you need to show that the victim suffered substantial abuse. Sarah, can I ask you a little bit, what kinds of things would you look at to show substantial abuse? Maybe for Anna's example or another example.
So certainly one of the best forms of evidence of the substantial harm is going to be the petitioner's own personal declaration, where they can talk about the impact that it's had on them, maybe if they're suffering, they're having difficulty sleeping, they're having nightmares, they're having hypervigilance. They can describe all of that in their personal declaration, which is a really important component of the declaration. You could also submit affidavits from, in this case, from Anna's mom. She could talk about the impact. Certainly if they are receiving any kind of counseling services, it's really, really helpful if you're listening in from a DV or SA agency, getting a letter confirming that this person is receiving services from the DBSA agency or counseling services, shelter services. That can really be helpful. In this case, in Anna, I think she initially confided in a guidance counselor. Maybe they would be willing to provide a letter. Yeah, those are some of the ways I might look to prove the substantial harm.
Yeah, and in some cases you might think this crime is so severe. I mean, it should be just obvious that this person has suffered as a result of this crime, but it's important not to neglect this because it is a required element as well. Okay, so once we've established substantial abuse, those are the things that have to be required, that have to be demonstrated for the visa, for the U visa application. In order for that to be approved, however, USCIS, as part of reviewing the case, is going to be doing an admissibility analysis. And what this really means is that they're going to be looking through the entire history of this person, any records that they have on how this person entered the United States, running criminal records, background checks, and if they find anything that could trigger a concern that would meet one of the elements in the statute that are described as grounds of inadmissibility, they could deny the visa just based on that. So even if you establish everything else we just talked about, let's say, for example, they find evidence in doing criminal background checks, checking fingerprints that your client they have a conviction for shoplifting. That could potentially be the reason that it's denied, because they have this, could be a ground of inadmissibility, and they could deny it. So it's very important that preparing these applications that clients are working with knowledgeable immigration attorneys or accredited representatives, because this can get really tricky and kind of technical. I've listed here some common grounds of inadmissibility, even as simple as having entered without inspection. That could be a reason, that is a reason, that the visa would be denied. However, it's possible to ask for a waiver, and we'll look at that in a sec. There's some other grounds here. False claims to U.S. citizenship, a very, very common thing that happens in immigrant communities, but it can be a big problem. So let us look at the waiver. The good news is that under the U visa, almost all grounds of inadmissibility can be waived. The exception would include severe things that I hope I never see, such as genocide, acts of torture, extrajudicial killings. Those things cannot be waived. But everything else, in theory, can be waived. In practice, however, more severe crimes, it can be very difficult to get a waiver approved, but you can try. The language in the statute is that you need to show that it's in the public or national interest for these grounds of inadmissibility, whatever they could be, to be waived, and that you need to show, and that's basically what that boils down to, is showing that the positive factors in this person's case outweigh this negative thing. Yeah. Any thoughts on that, Sarah? Yeah. So, I mean, it's similar thought process that we talked about with showing good moral character for VAWA, but it is a different analysis. Those things that would make someone ineligible to establish good moral character are different from the things that could make someone inadmissible. So you just really, it gets kind of technical, and you really need to be familiar with the differences. That concludes my review of the U visa, and we're going to turn now to a related form of release by looking at another hypo.
Okay, so this is Ruth. Ruth was in her final year in university in Kenya when a family friend suggested she meet Keith. They hit it off, and after a year of daily correspondence and chatting online, he flew to Kenya to meet her in person. They liked each other, and their families approved, so Keith returned to the U.S. and applied for a fiancé visa for Ruth. Here in the U.S., the reality of Ruth's situation was very different from what Keith had promised. He not only forced her repeatedly to have sex with him against her will, he also emotionally abused her. During the day, while he was at work, he insisted she care for his daughter from a previous relationship, which she had not known about. When she would ask about marriage, he laughed at her. Eventually, at a prenatal appointment, a nurse referred her to a domestic violence advocate. What might her options for immigration relief be, Diana?
Well, let's see. Does it seem that, let's look at VAWA first of all. It looks like she never got married to him. So we do have spousal abuse, but without a marriage certificate, I don't think we can show VAWA. So let me think about a U visa. So I'm looking at my list of crimes, and it does look like she's been a victim of a qualifying crime because she suffered rape. At this point, though, she hasn't actually cooperated or made any with law enforcement or made a report. So I guess I would say in theory she could be eligible for a U visa, but she would need to, that would need to be part of a discussion with the DV advocate about what her options might be. I am thinking of one other option, though. What do you think, Sarah?
Well, one interesting fact in her story is this kind of forced labor component where she didn't know that he had a child from a previous relationship, and I think that child in the past had been in daycare, but once Ruth arrived, her husband or her partner now forces her to provide child care. So I would be looking at, this as a potential trafficking situation with forced labor.
Wow, very good, Sarah. So, yes, this is exactly what I would look at for her. I would actually, in this case, I would probably look at both the U visa and the T visa, but I would particularly be interested in looking at this as a human trafficking case. And many people might not initially see human trafficking here. It doesn't exactly match the profile that we see in the news of what human trafficking victims look like. But if you go into, let me pull up the slide that will help with this, looking closely at how human trafficking is defined in the statute, it's defined actually fairly broadly. The elements in order to show that human trafficking has occurred is that you need to show an action, a means, and a purpose. The action, you need to show recruitment of someone for forced labor, harboring of them, transportation, provision, or obtaining of a person. How do you do that? You need to show that this occurred through force, fraud, or coercion. And then why was this done? What was the purpose? For a commercial sex act or for labor or services. And the reason I think Sarah thought of this in Ruth's situation was that we could say he recruited her, he persuaded her to come to the U.S. under this fraudulent promise to marry her, which he appeared he had no intention to do. And part of the reason was he wanted to have her at home so he would be able to pull his child out from child care and have her provide that. It's important to remember, just a little reminder that there's a difference between smuggling and trafficking. I just always like to mention that here. I think it's a very confusing term in some ways because trafficking makes it sound like there needs to be movement. It doesn't. Human trafficking, remember, is a crime against a person. It's about forced labor, and transportation may be an element. I mean, in the case of Ruth, we could say it's sort of an element. He brought her over here. But you might also be working with someone who entered without inspection. They came entirely of their own free will, and once they were here, they encountered a situation where they were forced into labor. They are still a victim of human trafficking, even though there was no movement at all. There was just the abusive forced labor situation. Sometimes people confuse it, of course, with smuggling, and smuggling would be a crime against the national border. That's about an illegal border crossing. Sometimes, again, a smuggling situation, a human smuggling situation, could turn into human trafficking, but they are distinct. So the reason that I would look at the T visa for Ruth, it's a visa that is intended for victims of human trafficking that are willing to assist law enforcement in the investigation or prosecution of their trafficking. And there is no wait list. So that is really the reason, one of the main reasons I would be excited to file a T visa for her. I might file it along with the U visa if I wasn't sure, I wasn't confident that the T visa was going to get approved. But if it is approved, she would be immediately granted the T visa. and which, just like the U visa, is 4 years with lawful non-immigrant status and a work permit. I think I covered the benefits at the end, but I'll just go into right now and to show the elements. In order to file for a T visa, she'll need to show first that she's a victim of human trafficking, that she's present in the U.S. on account of the trafficking, and that she's cooperated with requests from law enforcement. And finally, that she would suffer extreme hardship if removed from the United States. I'm going to look at each of those things in turn. So this is a point where, and when you look at these elements of the T visa, they probably remind you of a U visa because they are very similar. It's even similar into the U visa in the extent that there is a Supplement B law enforcement certification, but a key difference is that if you are unable to obtain the certification, the victim can also submit secondary evidence of helpfulness. So in Ruth's situation, at the moment that the hypo ended, is she eligible for a T visa at that point? Sarah, what do you think?
I don't think there was any mention in the hypo of any report or cooperation, so I'd say at that moment, no.
Right. So, if I were meeting with Ruth, I would, talk to her about if she chooses to make this report, that, this could be a next step that we would take. So after she's cooperated, I would approach, law enforcement and ask them to sign a law enforcement certification. In her case, I might see if they'd be willing to sign both a U visa and a T visa certification. However, if I were unable to obtain the certification for whatever reason, I could also go ahead and file just with her own testimony that she cooperated and maybe some documentation showing that she went to appointments. Maybe a DV advocate would be willing to also write a letter about how she cooperated. So you can think creatively about how to demonstrate helpfulness. Next, she needs to show that she's present in the U.S. on account of human trafficking. And this often, I think, dissuades people from filing who could actually file, because it gives the impression that you have to have originally entered the U.S. due to the trafficking. As I mentioned earlier, many people who successfully file for T visas may have entered for completely different reasons. The focus of the inquiry is not the reason the person came to the U.S. originally. The focus is really why they are still here, why they are now present in the U.S. on account of human trafficking. So that's about, when I'm filing these cases, I'm thinking about showing why the fact that they experienced human trafficking has made it very difficult for them to leave the U.S. There may be fears that if, in Ruth's case, maybe she's afraid that if she returns home, he has family there too that could cause problems for her. He is her trafficker in this case, so you would say that the trafficker would cause problems to her. There's no protections for her as a victim of human trafficking. Maybe she's experienced a lot of trauma due to the trafficking and can't access services that she needs in the home country. In some cases, particularly when the trafficker maybe has forced the victim to pay a lot of money in order to come to the U.S., there may be fears that they're going to cause problems for them due to this money that's still outstanding. So there's a lot of different ways to approach this, but the important thing to remember is that it doesn't require that you entered the U.S. originally due to the trafficking. And then finally, the person needs to establish that they would suffer extreme hardship if they were removed or forced to leave the United States. Ideally, you want to be able to show more than economic harm. Again, this is similar in some ways to how you might show that you're unable, either that you're present on account of. You might show that conditions in your home country, there would be no protection for you there, and that you fear the trafficker. Maybe the native country is dangerous because of war or civil violence. And this is an element that is very different from the U visa. It's an inquiry about what are conditions like in the home country. Sometimes human rights reports can be helpful in establishing the conditions someone might face if they had to go back. And finally, I alluded to this briefly earlier. These are the things someone who files a T visa could expect. They, again, as I mentioned, would have 4 years in T non-immigrant status, employment authorization during that time. One thing that someone with an approved T visa would have access to that a U visa would not would be access to extremely generous public benefits, similar to the benefits that refugees receive. They also have the option to apply sooner for lawful permanent residency. They can apply before the 3 years if they can show that the investigation has concluded. And like U visa applicants, they're also able to include derivative family members living in the U.S. and abroad who are able to receive the exact same benefits as the applicant. That concludes my discussion of the visas, and we're going to shift now to talk about some changes in immigration policy.
Thanks, Diana. So, as Diana mentioned, there are some issues, right, with these forms of release. There's long wait times. There's caps. There's wait lists. but they're also hugely, hugely beneficial to survivors and can really change someone's life. And these forms of relief have largely remained unchanged, but there have been a number of changes in immigration policy. And if you follow the news, or even if you try not to follow the news, you're probably hearing about all this shift in immigration policy, and it's making headlines every day. So we want to cover some of the most impactful changes and how they're impacting survivors in particular, crime victims in particular. So the first is this Interior Enforcement Executive Order. This is actually one of the first actions that this administration took back in January 2017. And what it did was really expand the priorities for immigration enforcement. Under previous administrations, there were certainly people being placed in removal proceedings, but there were priorities for who ICE was focusing on. Like if you had a prior order of removal, if you had a criminal history. And with this executive order, they really eliminated that and made anyone who's in the United States, essentially anyone in the United States undocumented, was a priority for removal. And so obviously this had a massive impact on survivors. And if you listen to that video at the beginning of the presentation, you would have heard some of this. What we've seen is really an increase in workplace and home raids related to that. We've seen more collateral arrests. So whereas in the past maybe ICE would show up at a house at 4 in the morning looking for one individual, and they would arrest and detain that one person, now what we see more frequently is that everyone in the house is kind of swept up, and more people are being arrested in these collateral arrests. We also see an increase in immigrant survivors that are being placed in removal proceedings, and this is true even of folks with pending applications. So Diana mentioned that once someone receives their receipt notices, that it affords them some level of protection. What we found is that kind of being diminished, and that more survivors are being placed in removal proceedings despite having a pending application. And what all of this leads to is an increased distrust in local and state law enforcement, which is hugely problematic. There was already a lot of distrust for a lot of different reasons, and this is really just exacerbating that problem. And as a result of that, we see a decrease in the reporting of victimization. So victims of domestic violence, of sexual assault, of other crimes are more reluctant to make reports and more reluctant to cooperate with law enforcement because they fear that as a result they're going to be placed in removal proceedings. So this executive order has really had a big negative impact on survivors and their families. In addition to those big executive orders and these kind of more headline-grabbing changes that you probably hear about, around family separation and turning asylum seekers away and all that stuff, there's actually a lot of kind of more subtle change that's going on at the agency level that you might not be hearing about, but folks who are doing this work are really seeing a lot of negative impact for survivors. One of those, and a lot of that stems from agency memos. So one of those memos was this Notice to Appear memo, which originally came out in June of last year. And basically USCIS announced that they would now begin to issue a Notice to Appear, which is like the document that initiates removal proceedings when an application was denied and the applicant doesn't have lawful presence. They don't have any other legal immigration status. So there is no criminal conviction required, no finding of fraud required, no arrest needed. It was just you applied for a benefit, it was denied, and you don't have any other form of legal immigration status. In the past, it used to be the risk in submitting these applications was very low because if your application was denied, generally it wasn't forwarded to ICE for enforcement. Really nothing happened. In September, they said that this was going to be implemented incrementally, and we were hoping that maybe it wasn't going to impact VAWA UNT applications. But in November of 2018, they announced that it was going to begin to apply to the Vermont Service Center's Humanitarian Division, which includes the VAWAs, U's, and T's. So as you can imagine, this really has a chilling effect. It's going to discourage people from applying from relief that they qualify for and are entitled to. I mean, it's really contrary to the intent of these laws. Like, in particular, the U visa as Diana mentioned, it was created as to be a tool for law enforcement to make victims feel more comfortable and safe in cooperating. And if they feel like by applying they're going to end up in deportation proceedings, obviously that's not going to happen.
And I would say that's particularly true for someone who, imagine a victim who's entered without inspection and is basically not on the radar at all of USCIS. So by submitting a U visa application now, this victim could very understandably feel like what they're doing is just putting their hand up in the air and providing all their information to immigration. So once down the road, once this case could, if it were to be denied, that they, whereas before they were unknown and off the radar, now they're known and could, immigration proceedings could become that could be initiated, which could impact not only them but their family.
Absolutely. It also really is once this, we haven't seen it really go into full effect, I would say, yet. I haven't seen or heard of anyone actually being NTA'd yet. But if it does happen, it's really going to increase the backlog in immigration court, which is already kind of astronomical. It really changes the function and the mission of USCIS, which is to adjudicate these cases and to grant benefits, and it really kind of makes them part of this deportation machine. Shortly after the NTA memo came out, they issued another memo with regard to requests for evidence and notices of intent to deny. In the past, when you would submit an application, if you maybe didn't have, they review your application and they feel like you could use more evidence of the substantial harm for a U visa, for example, what they would do is issue a request for evidence and tell you, we need more evidence of X, and you would have the opportunity to respond and later have the case approved. With this memo, basically they gave adjudicators the discretion to deny cases without issuing a request for evidence or a notice of intent to deny. And what this could result in is, more denials of folks who are eligible for the form of relief that they're seeking. And it also eliminated the possibility for skeletal filings, which sometimes, it's not something that we do frequently, but if someone, maybe they have a custody matter going on and there's a lot of threats to call ICE and that ICE is going to show up at the custody hearing, for example, we might quickly try to file a skeletal application and just get the kind of bare bones in so that that person has some level of protection, or maybe they've just come to you and their conditional residency is going to expire. But this makes that really difficult if you don't know if you're going to have the opportunity to supplement the application later. Another really huge and impactful change that we've seen is with regard to fee waiver processing. This is like my personal nightmare because previously they were very generous. The Vermont Service Center was very generous with fee waivers, and essentially we would submit a declaration that stated, these are my this is my income, these are my expenses, and I don't have the means to pay for these applications. As Diana mentioned, many of the applications are free, but there are a lot of ancillary applications like the inadmissibility waiver and, or the green card application, the work permit applications that are very, very costly. So those fees generally used to be waived pretty easily. And in July, the Vermont Service Center Humanitarian Division changed their fee waiver policy without giving any notice to stakeholders. So they didn't tell us, hey, we're going to change this policy. We're now going to require that you use this I-912 form to apply for fee waiver. They just started denying applications, rejecting fee waiver applications, and rejecting the U visa or the whatever the underlying application was. They would just send it back. So this caused some survivors to miss deadlines. Some survivors are finding it more difficult to qualify under the more stringent requirements. And really a lot of limited resources are being expended on refiling applications with denied fee waivers. And this is still going on. Just last week I was refiling a fee waiver because they're just being more kind of
It's just very arbitrary
yeah.
in terms of how these are being adjudicated, and it's very difficult for many of our clients who are low income. Not only are they low income, but they're just not. Maybe they're not filing taxes. It's very difficult for them to document that they are low income, even though they are low income. So it just can be extremely challenging.
And a lot of, and some people are opting to try to find ways to file these forms, which is a real hardship for people. Like, for example, the U visa, if you're filing a waiver for yourself and maybe 2 children, those are like $600 each. and then you're filing work permit applications on top of it. So you're getting into the thousands of dollars, even if you're getting free legal services and the initial form is free. So those are just some changes that we wanted to make you aware of. Obviously, these things are shifting every day, but we wanted to just highlight a few of those changes. And with all these changes, it's really becoming more important that we as service providers are really well prepared and welcoming to immigrant communities because of all these challenges that they're facing and all this shifting in policy that's going on. So let's talk about a few of the best practices for serving immigrant survivors and what your agency can do to be more responsive to the needs of immigrant survivors. So one of the first things that you can think about is your staffing. You want to look at your staff and ask yourself, is it really representative of the communities that you want to serve? And do you have the trust of the community members that you hope will access your services? I think it's really important to prioritize when you're hiring for new positions, as they become vacant, thinking about if you can prioritize somebody who is bilingual or bicultural so that you can build in more language capacity at your agency. Of course, if you're in a kind of a management role, you want to encourage staff to take advantage of training and just encourage that they practice cultural humility. Obviously, sometimes we offer, even through the network, we offer trainings where, sometimes people call, cultural competency. Certainly, we're not going to become competent in another culture after a 2-hour training. Even if we are of the same culture, everybody experiences culture differently, and you want to avoid making generalizations and assumptions about folks. So I think the best way to do that is to just really be humble and to recognize, that you don't know everything and ask questions and be respectful, and that's really the best that we can do. Also, you want to consider using when you're doing outreach into different communities, you're targeting different communities because you want to make sure that those communities are accessing your services. Think about also using those opportunities to try to recruit potential staff. The most successful DVSA programs in terms of serving immigrant survivors that I see are those that really have advocates that are there for a long time, that really have strong relationships with folks in the community and have the trust of the community. And I can't really stress enough how important that is. You also want to think about your physical space and your materials. Just looking around your waiting area or your shelter, what does it look like? If you were an immigrant survivor or a limited English proficient survivor, would you feel welcome there, and would you feel like these services were really for you? Thinking about the people who are in your brochures and the posters on your walls. Just doing a double check to make sure that they really reflect the community that you want to serve. Of course, language access is huge. You want to think about if your agency has a language access plan. Many agencies that I work with have a language access plan that was developed, years ago, and it's sitting on a shelf somewhere. So that's not particularly helpful, right? If you have a language access plan, when was the last time that you reviewed it? Is it working? Does everybody know what it is? Does everybody know how to access interpretation or translation if they need it? Think about what your, kind of do an assessment about what your agency's needs are, and think about how you can go about getting those needs met. And then also you're in a great position to kind of be monitoring what's going on with other agencies and entities like law enforcement or the courts. What are survivors' experiences with those agencies like, and are they doing what they should be doing in terms of language access, and how might you be able to advocate for survivors, for LEP survivors, to make sure that LEP survivors have the same access to our services and to legal protections that English-speaking survivors have.
A note on language access that I always like to remind myself to remember as well is that just because someone seems like they can make themselves understood in English, you may be missing so much if you don't offer them the opportunity to tell their story in the language of their choice. I mean, I even have trouble, sometimes I make this mistake in Spanish too, where I think I'm getting along fine in Spanish talking to someone, and then I realize that actually their first language may be like in an indigenous Guatemalan language. And then once I get that interpreter on the line, I realize there's so much more. So I just encourage you to, almost as a matter of course, train your staff to ask, are you comfortable in English? Please, would you like me to get an interpreter in another language? There's no cost to you if I do this.
Yes, that's a great point. Accompaniment and reporting, these are things that domestic violence and sexual assault agencies in particular are likely already doing. I just would really encourage folks to prioritize doing accompaniment and support survivors in reporting for immigrant survivors. You heard it in the video, and we've been taught, it's come up throughout this presentation, the kind of fear and the distrust in law enforcement. It's just such, when someone's going through, they've experienced trauma, they're in crisis, it's difficult for someone who doesn't have immigration concerns or who isn't a limited English speaker to kind of navigate these processes. And so it's just even more kind of challenging for immigrant survivors and LEP survivors. So to the extent that you're able to provide accompaniment, I think it's super helpful. Even if you don't speak the person's language, just having someone there that is kind of on your side and is monitoring what's happening, and that folks aren't being asked about their immigration status or feeling intimidated because of their immigration status is really, really important. And thinking also systemically, the same as you would do when you're kind of watching what's going on with the courts and law enforcement in terms of language access, you can also be just getting a feel for how immigrant survivors are being treated by law enforcement and the courts. In particular, something I'm always interested to hear is if police or law enforcement are asking victims about their immigration status. That's something that we would love to know about and would love to work with you on, because we know how kind of detrimental that can be. Making warm referrals, this is really important. Maybe if you're working with someone who's born and raised in the United States or an English speaker and you want to refer them to a clothing bank, for example, you might just hand them the phone number to a clothing bank. But if you're working with someone who is LEP, if you're giving someone a phone number and they're going to call in and have to go through 12 prompts in English, or they're going to show up somewhere and they're going to be asked for their social security number, likely your referral is really not going to have the impact that you want it to. So, of course, we want to keep our empowerment mindset and empower folks to do things for themselves, but just being available to provide extra support if it's needed, I think can really go a long way. And then, of course, if you're doing any safety planning, there are some unique concerns that immigrant survivors may have. You want to be sure to orient survivors to U.S. law and systems here. In particular, I've had so many people who, for example, the concept of marital rape just really don't recognize that. Some don't realize that your husband could rape you, because you can in fact say no to your husband. The laws around domestic violence vary in other countries. So you might just want to do some basic education about what is in fact against the law in the United States and what victims' rights are here. You can also direct people to documents for family planning, for family preparedness. This is planning for what's going to happen with someone's kids or what's going to happen with someone's house if they end up in removal proceedings, if they're detained. There are some great planning documents that are available from the ACLU and other organizations that you might be able to direct people to. You can also assist survivors with gathering or storing documents, particularly people's identity documents. In situations of domestic violence in particular, we find that abusers will often take and withhold identity documents or destroy identity documents, which can make it really difficult for the survivor to replace them, and they also may need them for an immigration petition. So this is a really helpful thing that advocates can do to kind of avoid problems later on if they're able to keep documents safe. And then finally,
I was just going to say, sometimes those documents might not be just the victim's own identity documents. They may also be documents that will be important in the immigration application that is coming. So maybe your victim is actually able to get a copy of her abuser's birth certificate. There's a window and she's able to make a copy. She is able to store that somewhere safe. That could be really beneficial. So those documents are going to be critical.
Yeah, absolutely. And then finally, Diana talked about this a couple of times throughout with the different forms of relief, that one of the things that can be really helpful is a service verification letter. And that's just to confirm that this person did seek services from a domestic violence or sexual assault agency. You'll be surprised how many times immigration responds with an RFE like, oh, if this person's really a victim, then surely they would have sought, domestic violence services, because all victims do. But it really does go a long way, and it's a big way that agencies can support survivors in their applications. So that concludes this webinar on advocating for immigrant victims of crime. You'll see our contact information here. Please do feel free to reach out to us if you have any questions or if you want to refer a case or need some technical assistance on a case that you're working with. We would be more than happy to speak with you. Thank you.
Thanks.